Go ahead, Nicole.
Okay, hello everyone. I'm just wondering if you could put the slides up, Greg.
Yep. Okay. Just a moment, thanks.
Oh, no problem.
Your screen. Perfect. Can you see that?
I can. Do you want to make it
Full
full
screen?
screen? Yeah. Click slideshow. Great. Okay, great. So thank you everyone for coming. My name is Nicole and I'm a third-year law student at Western Law, and I am in the advanced family clinical course this year, where Greg supervises us, and I will be starting off our presentation today and then passing it off to Marissa, another student in the course, and then coming back at the end. So we'll start things off with the land acknowledgement, if I can get Greg to go to the next slide. So we acknowledge that Western University is located on the traditional territories of the Anishinaabe, the Haudenosaunee, the Lenapehoik, and the Attawandaron peoples on lands that are connected to the London Township and the Sombra Treaties of 1796 and the Dish with One Spoon Covenant Wampum. This land continues to be home to diverse Indigenous peoples, including First Nations, Métis, and Inuit people, whom we recognize as the contemporary stewards of the land and vital contributors to our society. And even though not all of us are on Western campus right now, we do encourage you to look into the lands that you are currently occupying, and learn a little bit about them as well. And with that, I'll pass it off to Marissa.
Thanks, Nicole. So Greg, if you wanted to go on to the next slide. So we first just have to provide a disclaimer, which is that Nicole and I are both law students. So this presentation is being conducted by a law student who's not able to provide any legal advice. Presentation tonight is for general legal information, not legal advice that is specific to you and your family. The last slide of the PowerPoint will have resources you can contact about your specific questions. And then I'm good to go to the next slide. So first is the Child, Youth, and Family Services Act, otherwise known as the CYFSA. The purpose of the CYFSA is to protect the well-being of children and to serve the best interests of the children. It's a piece of legislation in Ontario that governs child protection, and it states that the least destructive course of action should always be considered when children are in need of help. First Nations, Inuit, and Métis communities should be given the opportunity to provide child services in a manner that respects and recognizes the culture, traditions, and heritages. And then just a little tidbit of information, the Government of Canada just announced a $20 billion settlement for First Nations child welfare. So next is the child protection agencies in Ontario, and there are three, which are the Children's Aid Societies and Child and Family Services, otherwise known as CAS, the Indigenous Child and Family Services Agencies, and the Ministry of Children, Community, and Social Services. So the Children's Aid Society, or CAS, does a lot of things, such as investigating allegations or evidence that children under the age of 18 might be in need of protection and protect children where necessary. They also provide guidance, counseling, and other services to families for protecting children or preventing circumstances requiring the protection of children. They also provide care for children assigned or committed to society care and supervise those children in care and can place children up for adoption. The Indigenous Child and Family Services Agencies delivers culturally appropriate services for the safety and well-being of children and families. And finally, the Ministry of Children, Community, and Social Services oversees the delivery of child protection services for children who have been or are at risk of being abused or neglected. They also provide financial and employment supports to low-income Ontarians, and they help prevent high-risk youth from coming into conflict with the law and improve their outcomes and reduce offending. And then there's just a little citation there at the bottom if you want to read more. And then you can go on to the next slide, Greg. So what does it mean to be in need of protection? And then on the next slide, it'll say, so CAS will remove a child from the care of a parent or guardian if they find them to be in need of protection. A child can be removed to a place of safety, which is or could be a member of the child's family, extended family, or community, and society or a place of authority that has assessed that a certain home is a place of safety for a child. CAS will determine if the child is at serious or immediate risk of harm, and if they determine there is a risk, then they can remove the child. This includes the child being left alone, uncared for, neglected, such as physical harm, or at risk of being in harm from neglect, sexual harm, etc. The child having been abused or is likely to be abused, or the child sees abuse or violence between adults. And then finally, a child who is 16 or 17 years old must consent to being removed from the home. It cannot be removed without consent. And then the next slide is removal at birth. So CAS can remove your child at birth if there's significant concern of harm to your child or fears for your child's safety. And some of these concerns may include a serious drug or alcohol problem, you're unhoused or have unsafe housing, or other types of instability. And you can move to the next slide, Greg. And the last slide is the duty to report. So there are 3 different duties to report for children aged 0 to 16. Anyone can report, including members of the public and professionals who work closely with children and youth, or are required by law to report suspected cases of child abuse or neglect for children aged 0 to 16 years. For children aged 16 to 17, everyone may report concerns pertaining to 16 and 17-year-old children. And then there's a professional duty to report. So the CYFSA recognizes that persons working closely with children and youth have a special awareness of the signs of child abuse and neglect, and a particular responsibility to report their suspicions and make it an offense to fail to report. And some examples of these professionals could be people working directly with the child, like teachers, doctors, daycare workers, preschool teachers. And that concludes my section of the presentation. So I'll hand it off to Nicola now.
Thanks, Marissa. So the next bit of the presentation is about what happens if the Children's Aid Society gets involved and if they do remove your child and take them to a place of safety. So we have a flowchart here that kind of goes over what some general steps may be. Not every case will look the same, but this is a general overview of what it may look like. So once there is a referral to the Children's Aid Society, 2 things can happen. There can either be an investigation, or the Children's Aid Society can say there's no need to investigate, everything is fine. At that point, they would move away from the case. However, if they do find that there is an investigation required, they will do that investigation and complete it. They can either determine after the investigation is completed that there are no protection services required, and again, leave the case there, or they can decide that there are ongoing services required and assign a family service worker. The family service worker will then do 3 things. So they can decide that the child should remain in their home with their caregivers, and they can do a long-term safety assessment. And once we know that there is safety long-term, they will close the file and again, move away from the family. However, there are 2 other things that the Children's Aid Society family service worker can do. So they can put the child into a short-term foster placement, or they can put the child into a kinship home, which would be somebody that the child knows, perhaps a family member or a close family friend. If they place the child with a kinship family, they can potentially move to have the kinship family obtain custody, or what we now call decision-making responsibility of the child. Or it's also possible that the child will be returned to their original caregiver once long-term safety has been achieved and the file will be closed. However, if the child does enter the foster care system, it is possible that they can be either they can be either returned to their family, or they can be put under what used to be called crown wardship and is now called extended society care. If there is a finding that the child is in need of protection, is in foster care, and needs to be placed in extended society care, they can either, this can result in long-term care where the child stays in foster care until they age out of the system, and that support will continue until they're 21 years of age. Or they can be find someone to take legal custody. Again, we now call this decision-making responsibility over that child. And once we have some semblance of permanency for the child, the file will be closed. And the last option is for somebody to adopt the child. And again, once we have that sense of permanency, the file will be closed. I think we can go to the next slide there, Greg.
Sorry, just trying here. There we go.
Great. So if your child has been removed from your care and taken to a place of safety, what should you do? So the first thing you should do is call a lawyer. There are several child protection and family lawyers in Southwestern Ontario that would be pleased to help you. And at the end of our slideshow, we will be providing some of those resources. It's also really important to keep notes on what happened. What are the relevant dates? What time was the child removed? How was your child acting? How were you acting? Who was present at the time? Did anyone say anything that you can remember? Are there any other details that are relevant that you can recall? The more information that you have, the better. However, lawyers are professionals that are able to assist even if you don't have this type of information. So once your child is removed to a place of safety, 5 things can happen. One of 5 things can happen in the 5 days after the apprehension. So first, the Children's Aid Society might return the child home. This would be if they did some type of investigation and found out there are no concerns, or if they find that no investigation was needed, or if it was just that the child needed to be removed for a day or 2. So the child could be returned home. It's also possible that the child could be returned to a parent with custodial rights, or that the society will engage the family in a temporary care agreement where the child would be cared by somebody else on a temporary basis. It's possible that the Children's Aid Society could also bring a child protection court application. So for a child to be found in need of protection, this is something that the court has to find as a matter of fact and law. So they will have to bring a case to make that finding. And the 5th option is that the child could be placed into a customary care agreement. So we can move to the next slide. So a lot of times caregivers will ask if they can see their child after they've been removed. And the short answer is it depends. So you can ask the Children's Aid Society or the family service worker assigned to your child about organizing visits. But before doing this, it's very important that you consult your lawyer. So this is why we recommend calling your lawyer or a lawyer as soon as you can after your child is removed from your care. And we can probably go to the next slide. So as I mentioned before, one of the 5 things that can happen within 5 days of an apprehension to a place of safety is that the Children's Aid Society can apply to the court to have a finding that the child is in need of protection. And this would allow the CAS to take more steps. So if it goes to court, a few different things can happen. So it's possible that the court will dismiss the case and find that the child is not in need of protection. And this would likely result in the child being returned to the caregiver's home. It's possible that a supervision order could be put into place whereby the society is able to supervise the family and ensure that the child is being cared for. It's also possible that the court would order that the child is placed in interim society care, which gives the society the ability to care for the child just on a temporary basis. Extended society care is the next step, and it is most often the most extreme step, whereby the child is put into the extended care of the society, and the society will be able to make decisions about the care of the child. And the last option is that the court might make a custody order or a decision-making responsibility order with respect to the child. And so we can go to our last slide here, which lays out some resources. So if your child is removed from your care and taken to a place of safety, you can call Legal Aid Ontario or the Family Law Information Center. There's also ATLOSA, which is located in London, and they help First Nations, Inuit, and Métis families. The other keywords that you might find helpful when you're searching perhaps online for a lawyer is someone who offers unbundled services or limited scope retainers. And that means that they'll be able to help you with these narrow issues, and it won't be as expensive as if you were taking on a lawyer with a full retainer. And then lastly, we do have a website available as well, which is stepstojustice.ca, and more information about this can be found there. And with that, I'll pass it back to Greg.
Okay, thank you very much, Nicole and Marissa. So now we're at the Q&A portion. I can certainly give some kind of general information and general legal advice, but I can't speak specifically to anyone's case if they are in a current case. And because this is a public forum, there's absolutely no confidentiality. So I would really not disclose anything personal if I were you. If folks want to ask a question in the chat, that's fine with me too. But other than that, I appreciate you guys coming out. Obviously, it was a briefer presentation, but we believe that for the public, this is some good bite-sized information to take away so that you do know your rights and the general steps on what to expect in a child protection case, and what is undoubtedly a very scary time for parents and families on the whole. So again, thank you for coming out for this, a very important but general and brief presentation. I'll just keep the line open for the next few minutes if folks want to ask a question. Again, you can use the chat. You don't have to unmute or show your video. Yes, go ahead, Nicole.
I'll ask a question, Greg. Could you perhaps give some more examples of situations where the society will intervene and potentially take the child to a place of safety?
Other examples, sorry. Certainly. Well, what I did want to talk about, and yes, the slides I don't know will be available, but the presentation on the whole will be recorded and available on our YouTube page, and so the slides will be a part of that. So hopefully that will be helpful. What I did want to talk about, and probably not answering this directly, Nicole, you spoke about in one of the slides, a removal of the child at the hospital, which you can imagine is a very traumatic event for all involved, to be clear. In most circumstances, I would say they definitely are not. They're definitely not. Scenarios where it's a surprise, right? The parents, CAS isn't going to show up at the hospital without ever having talked to a family, the parents or the mother. There will likely be some kind of communication between the parents, the mother, or what have you, about we're worried about this you know, your pregnancy, maybe the certain markers aren't being hit that need to be hit in terms of prenatal safety. And so I just want to make it clear for the public that we're not looking at CAS going in unannounced and a surprise visit to the hospital. They're my kind of general advice to folks that find themselves with involved with CAS is, you know, really try to work with them as best as possible, because, you know, everybody is trying to do what's best for the children. Having a good working relationship with your worker, your CAS worker, if you do find that, it is very helpful, because, you know, there is a mandate to return to the family if that is the least intrusive thing to do, and the children or child safety can be adequately protected. So I generally try to tell the public that, you know, try to work with them. I know the nature of it is very, you know, traumatic, and parents can feel helpless. But, you know, working with the society is also, the Children's Aid Society, it is going to be helpful. And so I really like to get that message out there. Who can be present at meetings? I see that in the chat. Who can be present at meetings with CAS? I think anybody who is part of the family plan. I mean, if you're talking about can a lawyer be there? I've done that and sat in on meetings prior to kind of official intervention from CAS to try to see if we can address some problems before they get out of hand, so to speak. But I also do think that is probably a good practice anyway, because, you know, you're going to want to know what your rights are, so to speak. Yes, and very good point. Indigenous band representatives can be present and should be present. We need to do a heck of a better job in making sure that cultural connections are being maintained as strongly as possible, and that that voice, Indigenous voices, are just as loud as anybody else in the child protection process. So most definitely, I mean, there are no kind of standardized rules that I know of that, you know, CAS or anybody can say you can't sit in on this meeting. Now, I mean, if you're not part of the family and you're not a community representative or a band representative who are trying to assist the family, then I can't imagine why you would want to sit in on the meeting. But you know, I think part of having other people at the table is so helpful, in that this is going to be a community kind of holistic approach to trying to solve this, solve whatever concerns there may be, instead of going the child protection route. So if you think that more people at the table to discuss the family plan and safety concerns and whatnot, I think the more the merrier, so long as, you know, they're not disruptive voices, or they're not irrelevant voices. Can a parent insist on being in an interview between the CAS and their child? Should the CAS be talking to the children alone in private? So there are many circumstances where the society will have a right to talk to the child privately. I can understand a parent's reticence about that and reluctance to do it. But it is also because, you know, there are scenarios where there may be some influence from a parent I'm not saying that that's common or in any case, but you could have that kind of specific worry, and there's going to be private interviews, especially if there's some sense that a child has made some disclosure about the parents, right? Uh, how is it appropriate in that circumstance that the child who, perhaps in any given scenario is afraid to disclose something about their parent, and they won't say anything if the parent is present for the meeting. But I do understand that anxiety about it. Any further questions? How does the parent counter misrepresentation by the CAS in their report? I think generally, I am not sure really what you mean by reports specifically, but I would say that if there is anything that you disagree with in the society's notes, in their report, or in their letter, or in their, if you're in court, in their pleadings, really try to get legal advice and determine how you can object to that, and how you can respond to it. Because the court, especially in court, unfortunately, that's the nature of court, is you're going to respond to things that you don't believe are factual. So, and you may perceive that as and understandably so. And I'm not saying that that's the wrong reaction to have, but you may perceive that as a misrepresentation, and you may say that in your response. And in court, the court will determine whether that's true or not. So that's how you would really assert your right in countering, as you say, any kind of misrepresentation or inaccurate allegation. Parents are not sure how to prove what was said. If you mean by like what a child said, that would likely, especially if you're in court, that would require, depending on the age of the child, the office of the children's lawyer to become involved, and they would have their own lawyer who would speak to them and get their instructions and their story, so to speak. So if you're talking about how you kind of reveal what children say, that's one of those avenues. But as you can imagine, that's a very difficult thing to do, because you don't want to involve the children if you don't really need to. I see something in the chat here. The CAS has 5 days to make a decision after they remove a child on the next steps. Yes, it's true. So if there's a formal intervention, and the child or the children are apprehended from their home, that's what it used to be called, and now it's called removal to a place of safety. But that's what's happening. The child is being taken from their home. It has to be back in court, or it has to be in court for a first appearance motion, I would call it. And in most cases, or not most cases, sorry, but it's not uncommon, because of how quick the turnaround has to be, because the society is mandated to, after they apprehend, be in court within 5 days. But what can happen is the parents may not have any paperwork. In fact, any court documents explaining why the child or children were taken from their care. They may have some idea, because they were likely communicating with CAS prior to then, but the legal allegations are not known. So that can be a very it can be a whirlwind experience, as you can imagine, for everybody, because you have had your child taken away, or your children, and now you're in court on the first day. You may think that is this the only court, and they're going to decide then that this is what's going on. I don't have my paperwork. In those circumstances, in the first appearance, what is likely available for parents is duty counsel, which is a free on-site lawyer who can look at the material, or if there's no material, understand the circumstances of what's going on. I did duty counsel for a while in those very scenarios, and what the court just wants to make sure of is that the child is at least being temporarily placed somewhere that where they will be safe. The parents, on the other hand, the order that is made against them on that day is called without prejudice, and it's temporary. So what that means is the parents are going to have their time to respond legally in court documents to the allegations that formed the or at least warranted from the society's perspective the removal to a place of safety. So then the parents can, hopefully with legal advice, schedule a motion to determine whether the society had cause to remove the child or children to a place of safety. We urge and encourage folks in that situation to get legal advice as soon as possible. Because and I see some society workers in attendance, as you know, especially with young children, time is of the essence in these cases, right? Things need to move quickly because, especially if a child is in society care, bonds between parent and children may be at risk of deteriorating attachments, especially if a very young child. So that it's such a critical period. So you want to be on the ball and getting a lawyer or some legal advice, if even an hour of independent legal advice, to be given a roadmap on how to move forward. And as in the slide said, in a case of a removal to a place of safety, you can also talk with your worker. How can I have parenting time in the meantime? What is that going to look like? What's the safety plan? Doing that is helpful as well. Because nobody gets into this job wanting to keep in the legal field, in the child protection field. Nobody got into it wanting to keep children away from their parents, right? Sometimes circumstances warrant it, hopefully rarely. But we're hopefully all trying to keep the family unit intact. Any further questions? Thank you for your questions, by the way. They're great. Legislation is online for people to understand the role and responsibility of CASs and well-being. The coding for received is called the eligibility spectrum and child protection. Okay. Yes, thank you for that. I appreciate it. Yeah. And there is no doubt that like I could talk about child protection issues and child protection law until I'm blue in the face. But tonight is a general information session, and hopefully you follow up on those resources if you find yourself in need of them. But yeah, certainly there's also steps to justice. If you click that link in the last slide, that's very helpful too. Obviously, it's not going to go into incredible detail, but it helps in giving the roadmap to parties that find themselves involved in circumstances such as these. Anything further? Oh, thank you for that. Yes, we're very happy that people come out because it's just vital information for the public, just to be prepared and again know their rights and know how to hopefully work with the society so that it doesn't devolve into 2-3 years of litigation and people kind of digging their heels in their respective respective corners, I would say. Okay. You can sign off if you want. I will probably keep the line open for 5 more minutes or so, in case anybody has any further questions. You're very welcome. Thank you for the claps, Marissa. Off topic, I did learn that by doing this, just that, it puts your hand signal up. So you can take that away as well. Yeah. I'm going to stop recording now. Okay.